Is mediating mandatory in divorces? That's our topic for today, part of the series, Mediating with or Without Attorneys with Tye Bourdony. Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact dependent. Hey everyone, this is Mac Pierre-Louis, attorney, mediator, arbitrator, working throughout Florida and Texas.
And Natalia Ołowska-Czajka, advocate and mediator in Poland and in Texas.
And Tye Bourdony, I'm a full-time mediator and a primary mediation trainer here in Central Florida, Orlando.
All right, everyone. So we are back with a great topic, this time dealing with mandatory mediations in divorces. And just note that we're in several different jurisdictions around the world here. So when you hear our anecdotes, stories, examples, stuff like that, keep in mind that it kind of depends on where you're located and what jurisdiction you're dealing with. And so this one is an important topic because parties have to mediate typically in most court cases. However, people still ask the question whether or not they need to do it by a court order or they have to do it by some law or some rule, whether they can skip it. So we're delving into that today to just discuss when it's necessary, when it's not, and what are the benefits of maybe not doing it, or which we would never, persuade people to not do it, not do mediation, of course. But Tye, why don't you take a stab at this? So when is it best to mediate, if at all?
Loaded question, right? I want to say it really depends on the parties. It's case by case with respect to when should they mediate. So in Florida, if there are issues between the parties with where children or minor children are concerned, yeah, they're going to be sent to mediation. If there's property issues between the parties, yeah, they're going to be sent to mediation. It will be mandatory, right? It's for judicial economy alone. The courts here in Florida have recognized that mediation really does do a great job in helping the parties. Who better to figure it out than the parties most times? Now, with that said, sometimes you do have uncontested cases, and the parties, they can take care of it. And so if it's an uncontested case, you don't have to go to mediation. But most folks who call me, they're going to call me either because they've heard about mediation, they believe in mediation, maybe they want to do it before, so you can actually do something called a pre-suit mediation before anything has been filed in court. Not for everybody. It's for those individuals who can work together more. Maybe it's not working out in the marriage, but maybe they can work together to, figure it out in a way that is more conducive from a time perspective, that is not going to be as expensive. You can have attorneys beforehand in mediation before anything is filed. Always a good idea to seek legal counsel. Your mediator cannot can't give you legal advice. It's not our role. We're everybody's neutral. Does everybody need a lawyer? No. Should everybody talk to a lawyer? Yes, I think they should. To know what the law is and what it is that what rights you have. And then the parties, who better to figure it out than the parties when it works, right? But not pre-suit is not good for everybody. And so you can always just, of course, go and file, and the court will order you to go to mediation here in Florida. So when I was the staff mediator, I would see the folks who filed, and then months later, they would get in front of me. So it's case by case, isn't it? How about, where you are in Texas, and how about where you are, Natalia, in Poland?
Yeah. Natalia, go ahead.
So Poland, as mostly all of the European Union, is very much enhancing mediation. That's actually one of the European Union goals. You need to go to mediation. Mediation remains voluntary. You can still say no, but the court will do everything, and the law will be created the way that you should at least and this is the case of Poland, you go to any civil case, including divorce, which is also a civil case, being a family case, you go to the court and you need to explain whether you were in mediation or you were not. If you don't do that, it's like your petition is not valid. You need to explain that you will be summoned to rectify it. Have you or have you not mediated? And then it is a discretion of the courts to direct you to mediation, which again, you can say, no, I'm not interested. And still mediation can be a pre-suit mediation, and within the proceedings mediation, the parties need to, of course, agree to that, but it's been proving so effective that it's absolutely worthwhile.
So, in my jurisdictions where I work, predominantly down here in South Florida, yes, all the judges require mediation before you step foot in court, either for temporary orders or before a final trial. Okay, if you're going to have a hearing with a judge, you're going to have to tried to work
Mhm.
things out first with a third party neutral.
Right.
So just like you guys, pretty common, pretty standard stuff. Now, our law does provide some exceptions, and one of them being family violence, of course. And so we have the ability for a person who does not want to go to mediation, even though it's mandatory, they can file a motion to waive mediation so that nobody has to go. I had a case once.
Mac, I'm sorry, Texas or Florida?
It is Texas.
Texas, Texas.
Yes, yes. It's specifically in our code where you can file to waive mediation, and for good cause, the judge can waive it. And again, the most common reason it's ever going to be waived is going to be violence. I've never seen another reason why it's waived. Judges are going to make you go. All right.
Mhm.
Now, unless, of course, the judge just doesn't believe in mediation, or they're just, they have so much time and they want to have cases, they want to just hear good parties. But no, generally speaking, it's in our statutes multiple places that it's a state's policy to encourage
Yeah.
early settlement of disputes. And so the story I was going back to is some years back, I recall um, a situation where I represent one party and I was not the mediator. We went to court. And I know the court's rules in this particular district court required mediation. And we were there on a motion by the other side asking the judge to waive mediation due to allegations of family violence. I didn't know what was going to happen. I told my client, well, it's permitted, they can object, and then we'll see what the judge says. So we go in there, and it was he said, she said, that kind of thing. But at
Yeah.
the end of the day, the judge says, no, you're going to go to mediation. Anyway, but the judge sent us to a particular mediator, one
Mhm.
mediator who had a pretty weird looking office. It was like a home, but there's a gate on the side where one party was able to go to one entrance and the other party was able to go to another entrance. They never saw each other anyway. It stayed caucus style mediation the whole entire time. So they were
Right.
never physically in the same place. However, they were able to both meet at the location and mediate. And we resolved the case. It worked out. At the end of the whole thing, literally these two are out on the street in front of the house talking. So apparently, the issue of violence was not as serious as one might think, but they were both voluntarily out there after mediation, when we're all going home. They were out there chatting it up.
Mm.
So that's really the only exceptions to the mandatory nature of mediation. But what
Mm.
about you guys? Do you guys have exceptions to mediations in your jurisdictions?
Natalia?
I'm civil case, general rule, you go. There isn't anything like that. You just, but still being voluntary, you can say, no, I'm not interested. And you don't have to give reasons for that.
Mm.
So it's totally given to the discretion of the parties.
That's interesting. To go back to kind of what you were saying, Mac, what I like now about virtual mediation is particularly where the mediator or the court might have reservations or concerns. Virtual mediation can really help in instances where we have domestic violence issues. Now, let's say there's an injunction. Parties can still go to mediation if there's an injunction, so that just getting to mediation, so even one door and going through another, would you technically be violating the terms of the injunction? For mediation, you can still go, so you wouldn't necessarily have to worry about that. But again, for me now, virtual is the answer to those kinds of issues, right? Because it just, now they're going to be more comfortable. They're not going to see them. They're not going to worry about them. I mean, they're still going to be nervous, but it just takes some of that awkward dynamic away because we can do virtual. But for the most part, one way or another, if there's minor children at issue or property at issue, you're going to mediation in Florida. You can either do it yourself or you can let the court order you, and then you can go to one of the courthouse ADR departments. But my only thinking is there can be exceptions for domestic violence. They can still mediate, but we can just handle it better. And I'm going that way just because of, kind of what you said. But then the question becomes, well, who has to mediate what and when, right?
Yeah.
And
Go ahead, Natalia.
this is what I really wanted to ask, because we already know we are going to mediation, we already know it is going to be divorce, but I want to ask you a very specific question. So what issues do they need, or do they may they mediate?
Right. Great question. And so one, I'm sorry, let me backtrack. Marital settlement agreement is one of the agreements that you have to work on, and a parenting plan. If you have children, you need the parenting plan. People sometimes don't have kids. Maybe they have dogs and cats, but they don't have kids. So they don't have to do a parenting plan. They may only have to do a marital settlement agreement. And so a marital settlement agreement is for everything other than anything related to the kids, all manner of property, real property, houses, cars, boats, vehicles, debts, accounts, things like alimony, things like, well, what about my pension? Things like intangible assets, checking accounts, savings accounts, right? And then it's, well, what did people plead for as well, right? So the question is, if no one asks about alimony, does the mediator bring up alimony or what have you? But again, to the most important part is, what are their circumstances? Are there minor children, and do they have property? They've got to do both. Are there no children? Then they've just got to do property, right? And if they're coming to mediation, it's because there's some issue at bay and they haven't done an uncontested, generally speaking.
And Mac, what about your jurisdiction?
Well, the issues to be mediated, just like what Tye says, kids issues or property issues. That's typically the things they fall, into. There are some weirder, situations that might come up, but we're focusing right now mostly on family, and so yeah, those are the only two things that we need to think about.
Modifications as well, right?
So
They could
yeah,
come after judgment.
correct. I mean, there are some things that I guess could be mediated, but I've never seen it, like a termination of one parent's rights, for example,
Ooh,
and how that
once in
might
a
look
blue
like.
moon.
Yeah, yeah, kind of rare.
Rare.
I've never seen it in Texas, of course. Um, but starting an order for the first time, modifying the order, and then sometimes abating the order or wrapping it up. Okay, those are going to be the three types of things you're going to have to touch upon.
Or orders from some other jurisdiction, and then you got to try and, but depends on what's going on, case by case.
Yeah, yeah. In my situation, it's probably going to be child support modifications a whole lot because I
Mhm.
used to work for the state,
Right.
child support office, and because of that, I'm getting child support calls and cases every single day, and so I'm always involved, crunching numbers, talking about medical support, constantly dealing with arrearages that people
Mhm.
owe to other people. Well, let's face it,
Yep.
dads owe to
Yep.
moms, and so it's a constant, chronic thing. So whenever I get a call, especially from a father who might owe a lot of back child support, or a mom who might be owed a lot of child support, I'll say, look, you don't have to mediate this because sometimes it's an enforcement issue at that point.
Right.
But mediation is a great way to actually resolve the dispute. And so, sir, make her an offer. What do you have to lose to try to get rid of this debt? Or, ma'am, would you be willing to take a lump sum, okay, in exchange for wiping out some of the arrears instead of having to take little by little on a payment plan across 15 years? So that's always a good one. I think probably one of the topics that should be mediated all the time because arrearages and child support can create so much bitterness between people, especially when the children are already in their 20s and 30s.
And I need to tell you that this is the trickiest thing here, because first of all, we can, in divorce, mediate the things that really fall into the scope of divorce, which is, of course, divorcing, which is the children, the parental rights, the child support, potential spousal support, so alimony for the spouse, and contact, so visitation rights, or care custody, and that would be it. Mediation of property is not a part of divorce, so you can have totally separate cases.
Really?
However, one trickier thing is even more, we still have in Poland, in family law, the fault-based divorce.
Ah,
And that's the thing where the judges really want to send parties to mediation because
sure.
uh, parties can mediate to just ab- abandon the adjudication of guilt, and usually that goes in line with some sort of property settlement. So someone gets some more convenient uh, share in the marital part of, and then the divorce goes smoothly. So it's trickier because this is a part where people try to, I wouldn't say blackmail, but act a little bit, okay, I
Yeah.
have something against you, so this is a strong argument. If you want a quick divorce, you need to give me something special.
Hmm. That's interesting that you say that Florida is a no fault state, right? But we still are arguing about whose fault it is sometimes, right? Or are we not? And so we have to help them get past some of those issues. So we're doing so much more in mediation than because whether or not it's a fault state or not, we have to talk about some of these issues, sometimes because emotions are such a big part of what we're doing in family law, right? Um, uh, when you're mediating with them, they're feeling the emotions that they were feeling when this has happened. And so it might be a year ago, it might be 2 years ago, it might be 3 months ago, but we find them in these emotional states. And so we have to try and help them through it. And so sometimes it's helpful that like I like to start with the marital settlement agreement. I like to start with the property issues first, only because they're not as numerous as the parenting plan issues. And sometimes there's less issues there than there are on the other side. Don't get me wrong, it's case by case. Sometimes, and I wish this happened more, the parties know they can't be together anymore, but where the kids are concerned, everyone loves the kids. They're going to do the right thing for the kids. It's the property. That's where they go nuts. Again, case by case, you just don't know. But we take them as they come to us, and we have to shift. The mediator has to shift based on what he or she is hearing and where the people are coming from. And typically, if there's kids and there's property, I'm taking them through it. And I'm going to start at the house, and I'm going to go to the cars, and then I'm going to go to I'll go to the property after the house, then the cars, then I'll go to the accounts, then I'll go to the marital debts, and then I'll go to marital debts and then accounts, because at the end of accounts, after I talk about checking accounts and savings accounts and other intangibles like crypto, I'm a big crypto fan. Then I'll bring up retirement, and then I go to alimony, and I leave those last because a lot of times where we're going to have problems is the retirement or alimony. Don't get me wrong, I start off with house. That could be a huge issue, as well. I tend not to try and go to the big issues first. I like to go for the low-hanging fruit and kind of show people, wow, you're doing a great job, but it's case by case. But then I'll go to the children issues, and I'll go through them, and typically I leave child support because you have to know so many things before you can do child support, right? You have to know who's the majority time sharing parent, how many in Florida, how many overnights. That's how we calculate child support, right? What's everyone's monthly income? What are you paying for health insurance? Who's paying for the minor child? What about daycare costs? What about how many overnights do each of the parents have? And there could be a few other things, but if we don't know all those things, it's kind of hard to do child support. Plus, in Florida, at least in the Ninth Circuit, if the Department of Revenue is involved, if there has been some kind of court ordered child support, sometimes we don't handle it because it's that court that has jurisdiction. Maybe somebody was given some entitlement, food stamps or Medicaid, something of Medicare, something of that nature. Well, typically the state is looking to get that money back from the other parent. And so while it's not typically, you can't negotiate child support because that's not mom's money or dad's money. That's the minor child's money. Rearages, like you were saying, Mac, are a little bit different. The parties can negotiate rearages between themselves, unless the state has the state has a stake in it, and then typically we have to reserve and let the case. So it's case by case. It really depends on how they're coming to us, when they're coming to us, what their issues are. Right? It's different for everybody.
Yes. All right, guys, and with that, we're going to be wrapping up. So this topic was on whether or not mediation is mandatory in divorces, and the overwhelming answer is yes, uh, with some exceptions.
Mm.
All right, guys, if you like this video, check out all the other videos we've been doing with Tye for a very long time now. Thank you so much, Tye, for your wisdom. All right, until next time, everybody.
Likewise.
Take care.
Take care.
Bye.
Bye.